Ifiemi Andrew. And so, after that interview, where former Governor El-Rufai said someone tapped the phone of Nuhu Ribadu and gave them certain information. And he also accused the government of tapping phone calls as well without orders from court. We then saw him say he was going to visit the EFCC who had invited him and commended them for being professional. He went and now has been detained. There were supporters of him who also were seen in videos being tear-gassed. The DSS has also filed a suit in court, and about 3 charges, if I'm not mistaken. I think about 3 charges, yes. Federal government filed 3-count charges against the former Kaduna State governor. The government filed these charges against him concerning the interception allegations of calls that were intercepted, amongst others. Well, this morning, we would look at provisions of the law as it concerns this and seek to find out whether or not there is a case in all of this. If you want to look at what the Constitution says, Section 37 of the Constitution makes it clear. It provides and guarantees the privacy and protection of citizens and their homes, their emails, letters, telephone conversations, telegraph communications. So you can't, beyond even, if you then even tap, you can't tap the call of an ordinary Nigerian. If you then tap the call of someone in public office, it might even be considered, in this case, one of national security advisor. It might be treated as espionage or threat to national security, whatever. They have all of this. The Cyber Crimes Act of 2015 also specifically criminalizes the interception of electronic communication. All right. But then there are exceptions where people can tap. In a case where it's a threat to national security, public safety, or criminal investigation, there are orders from court that comes and allows government or whoever is involved and whatever the case may be to tap a call. But the main question is, where does this go to? Does this case now filed by the federal government, does it have any grounds? Let's find out. We'll be speaking with a legal practitioner, Sogbeye Eli, this morning. Mr. Eli, good morning. Thank you for joining us.
Yeah, good morning, Ifiemi Andrew.
All right.
Thanks for having me.
Thank you very much. Just to not take much of your time, the case of the federal government that's been filed in the court with 3-count charge against El-Rufai. I'm sure you're aware by now of that interview where he said an unnamed individual listened to the conversation of Ribadu and informed him of some actions that were to be taken. Do you think that does the government have a case here?
Well, at the mix of not finding prejudicial, since the matter is already sub judice, I would say, first things first, you've identified the laws. Section 37 of the Constitution prohibits unlawful access or interference in somebody's telephones or other forms of communication. The Cyber Crimes Act itself, that was first enacted in May 2015 and then amended in February 2024, prohibits completely any form of cyber stalking, cyber squatting, and force punishment for such activities are tantamount to encroaching or invading anybody's privacy. So, on the grounds, the facts appear to be that the crime has been committed. But beyond the commission of a crime, when a suit is filed in court or charges are levied against one who is accused of committing a crime, the onus is now on the prosecution to prove. I saw the charge yesterday filed by the DSS. There are 2 questions arose first in my mind. One, is the DSS, properly so-called, the kind of is it a prosecutorial agency under our laws, under the National Security Agencies Act? That's what they call the State Security Service, SSS, and not DSS. So that's what is the name of DSS. So if I was a lawyer for El-Rufai, the first part of objection, the objection would be that this charge is incompetent because coming from a prosecutorial agency not known to law. Number one. Number two, now the burden of proving that somebody wiretapped the NSA's telephone will be on the prosecution to prove. Now, who is the person? El-Rufai did not name who he was referring to. That's not a hard nut to crack. But in the law of criminal prosecution, the burden of proof is beyond reasonable doubt. You must leave nothing to doubt. Every reasonable person listening to the case will say, okay, if A happened and B happened, therefore C happened. You cannot just come and set up a template that leaves gaps. And that's why most times prosecutions fail in Nigerian criminal law and practice. So, my worry is the burden of proving that indeed the telephone line of the National Security Advisor was tapped is not on the matter as alleged, because he didn't say he was not tapped it. So if you refuse to disclose who told him, and don't forget the law says he has the right to be silent. In fact, when the police come to arrest anyone for committing a crime, allegedly committing a crime, they will quote what they call the judge's rules. They have a right to remain silent. Whatever he said will be used against you in the court of law. So, in the court of law too, the law recognizes the right to silence. The man could go to court and say to mention who was the one that informed him that the line of the NSA was.
So, in other words, this is going to be a very difficult nut to crack. Is it also appropriate to expect that the DSS in this case might have to bring that recording to court to prove that, okay, this was the conversation that was tapped?
Of course, they must bring every ingredient of the offense to prove it. For instance, if the police charges anyone